All right, the 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding on this session. The court will call the case of LV NV Funding LLC versus Carlos Harris and Carlos Harris versus LV NV Funding LLC.
Good afternoon,
Good afternoon, Your Honor. Cezanne Varda, P65425 on behalf of the plaintiff.
And this is Carlos Harris here as the defendant.
Thank you. All right, we're here on a number of motions today, and I have a couple of other cases that are still in breakout rooms. I was trying to wait to give them a chance to come out to see if we could handle their short matters first. I suspect this one will not be short. So what I'm actually saying is that I'm asking that you give me some grace in this and that. If we need to take a break so I can deal with those short matters, I will do that. But I just wanted you to be aware of that.
Yes, ma'am.
Yes, ma'am.
All right. So we have a motion for summary disposition, a motion to remove to circuit court. I think that procedurally, of course, this one's on comes back. Procedurally, we should deal with a motion to remove it to circuit court first. Because
Yes,
so you can make your arguments, Mr. Harris.
Well, Your Honor, I received this suit the early part of December. And this has been a matter that has been going on for the past year plus with LV NV. We'll start off with SoFi. And I've been asking repeatedly for some documents that were never presented. And at one point, it ended up being charged off. LV NV ended up with it. When LV NV received it, I was given notification from their counterpart, Resurgent, I think it is, that they had filed for it to be on my credit report. And I filed a dispute with that in the Consumer Financial Protection Bureau as it related to it, because I've been asking for documents even before they received it. And so they said at the time that they were actually going to take it off my profile and that it wouldn't be affected. Well, sometime in September, it was posted again.
Mr. Harris, are you referring to the letter that they sent you? Is that what you're saying? Says what you're claiming you just said right now?
No, they actually put it on my credit profile. Resurgent, I think it is part.
You said that someone said to you that they weren't going to be pursuing it?
No, that it would not be on my credit profile. It was part of the response that I received from the CFPB. And I think I have it as an exhibit within.
Oh, that's what I'm asking you. That exhibit, are you saying that says that they said they won't be reporting it? It says they hadn't reported it at the time. It doesn't say they're not going to report it in the future.
Okay. All right. So at that time, they took it off my credit report, and I thought it was done. Then it went back. They said they were sending it back to LVNV. And so then it was again placed on the report in September by, I think, Halstead. So Halstead, I filed another complaint against them. And at that time, they said that they weren't going to pursue it because it was out for litigation. And that was in September. So in December, I received this complaint from the plaintiff as it relates to it. I truly believe that, one, that they don't have the standing in order to bring this complaint at this time. I've been asking for documents even before they receive this. And until they have proved that they actually have what I've requested, then I don't think that there's no way that we can proceed forth in light of me actually filing the counterclaim as well. And so I believe that I'm entitled to have this resolved in a court of competent jurisdiction. And I would believe that the right place for this matter at this time would be in the circuit court, which is why I filed the motion in order to have it transferred upon me receiving the complaint from them.
And what is your basis to have it transferred to circuit court, sir?
Number one, the monetary damages that I'm asking for exceeds the $25,000 cap that's on the district court at this time. So I think statutorily, I'm entitled to have it removed to a jurisdiction that actually can hear the claims that I have as it relates to the $100,000 compensatory damages that I've requested.
Compensatory. All right, thank you.
Thank you.
Mr. Barta, we can start with his argument regarding the $100,000 that he says he's demanding in terms of compensatory damages.
Your Honor, this court definitely has the authority to transfer this to circuit court if it wishes. However, I'm hoping that this court can see through the frivolous nature of a straightforward collection matter with the original creditor SoFi, where the defendant is already admitted to having the account, already admitted to receiving the funds and making payments on those funds, also evidenced by the documents attached to our motion for summary disposition, that this is a straightforward matter for credit extended and credit not paid back. My client couldn't get his money, so we went to the district court and we filed our complaint with the district court. Now, to file a counterclaim for sorry.
Go ahead. No, go ahead. That you get it to the part that I wanted to address.
Yeah, to file a counter complaint for $100,000 when you haven't even listed the damages. I understand that he does have buzzwords, FDCPA violation. I can go through his counter complaint and list them, but I don't know where are the damages? What did my client do wrong for Mr. Harris to have any damages, even 50 cents in damages? I just don't see it. It's frivolous. He's going to claim that his credit score went down, so he might not have been able to get money or it hurt him financially. However, the credit score goes down when you don't pay your debts back. I just want to, he's filed 48 pages and he has filed 40, but he has never stated why he doesn't owe the original creditor. And he hasn't stated where he gets any amount of damages. He just files a counterclaim, throws a whole bunch of legalese and says, I'm owed $100,000. I don't see it. Now, the court can kick it to circuit court so they can make the determination, but I'm hoping that this district court, Judge Washington, will be able to see that this is a frivolous counterclaim and that his counterclaim should just be dismissed. But that's not up yet. Right now, I don't believe it should be transferred to circuit court. I believe it should stay with you for you to determine the other motions. And his remedy would then be to appeal to the circuit court. And if they believe they should hear it based on his motion, then they can grant his appeal and listen to the case. But I do believe this court can determine whether this counterclaim is valid or not valid. Thank you, Your Honor.
So he asserts in his first pleading that I don't have jurisdiction because he's asserting a claim above my jurisdictional limit. So basically, even if I agree with every piece of your argument, which I might, what law grants me the authority to keep it at this court? I mean, he may go to circuit court and get hit with a whole bunch of sanctions up there if that's what he's choosing to do. But what authority do I have to keep this case here? I don't see it as discretionary. I think that if I keep a case and I don't actually have jurisdiction, then that's a problem. So
I mean, I do think that a counterclaim still has to plead something whereby damages can be afforded.
Isn't there some motion that you're supposed to file regarding that for me to be able to address that issue? Because all I have right now is your motion for summary as to your claim and his counterclaim asking for $100,000 where he's saying I don't have jurisdiction.
Yeah, so I'll leave it up to the court's discretion. If the court wishes to adjourn it for me to file that response to that specific argument, I can, or the court can just grant his motion to send it to circuit court, and then we'll just be back before you in 6 months after it gets kicked back.
Your Honor, may I say something, please?
Certainly.
Okay, so Last time we were here, it wasn't with this attorney here. I'm sorry, I don't know your name, sir. But when we were here last, I filed this motion in well enough time for the plaintiffs to respond to it, right? So we're here today, and what they filed was for summary disposition based upon the frivolousness of the complaint that they filed. And with my motion being filed,
They filed a motion for summary disposition as to their claim as I read it.
yes, ma'am. But if he's stating that he would need time now in order to file a response specifically to my motion, they had that time a month and a half ago, which we adjourned that until today to be able to have you consider the motion as it's stated. It's real simple as I've placed it on the record as of right now. Under MCR 4.002A, the court doesn't have any discretion as to whether or not it sends it over to the circuit court. As to whether or not the plaintiff believes that the damages are frivolous, that has no bearing whatsoever on the rule. The court does not have the jurisdiction in order to continue with this matter and must send it over. Now, if they would like to argue once we get over to the circuit court as to the frivolousness of my damages or my claims, fine and dandy, we can do it there. But as of today, I believe wholeheartedly that the court does not have the jurisdiction in order to proceed in this matter, and therefore it should be sent over as soon as possible.
Thank you. So, Mr. Barter, I'm looking through your motion. You asked me to dismiss his claim, but I see that it's referenced in the header here, but I'm trying to see where the law is that grants me that authority in this particular motion.
Your Honor, it's okay. We can send it to, the faster it gets to circuit court, the faster it'll get back before you. So I have no problem with going to
I
circuit
agree
court.
with you. This matter will be sent over to transferred to the circuit court. And please prepare an order to that effect. Mr. Barter, it might make sense for you to prepare it, since you probably can get it in and get it to the court quicker. I believe that, Mr. Harris, you'll need to file the filing fee at the circuit court,
Yes,
if it
ma'am.
wasn't for that to happen. So
Thank you, Your Honor.
I will sign an order to that effect.
Thank you, Your
Thank
Honor.
you.